Your Honor, I'm guilty.
Your Honor,
no, you're not guilty. Miss Owens, you've been through this before. You've got a ton of larceny convictions, right? This isn't your first rodeo. And ma'am, you're not required to enter a plea of guilty. But if you think you're going to sit here, I'm talking. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Your jury trial date in the mail. We're all set, ma'am. I'll see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail. So these are the people versus J.C. Owens. Can I get your appearance?
Yes, thank you, Judge. Andrew Mickus on behalf of Ms. Owens, P76268. Ms. Owens would waive any objections to appearing via video today as well, Your Honor.
Okay. All right. Did you speak with Mr. Zick this morning?
I did, yes, Your Honor. I think we've reached a mutually agreeable resolution to the matter. Ms. Owens is going to be entering a plea of guilty to one of the matters, and the court will be dismissing, Mr. Zick will be dismissing the other matter. We didn't get specifics as to case numbers, but there.
All right, folks, buckle up, because what you're about to watch is courtroom chaos in its purest form. Meet J.C. Owens, a repeat offender who somehow managed to turn a simple shoplifting plea into a full-blown legal circus. This case is everything: confusion, contradiction, and one very patient judge trying to make sense of it all. From claiming she's guilty one second to saying she's innocent the next, Owens drags the entire courtroom into a whirlwind of frustration. But here's the twist. This isn't her first run-in with the law. With a history of larceny convictions already on her record, you'd think she'd know the drill by now. So why is she risking it all again? Let's dive in, because this hearing goes from routine to ridiculous faster than you can say objection.
Essentially identical. She would agree to any restitution amount. He did not have a figure before him. I estimate that figure is going to be 0, because I believe all of the items were recovered in both cases at the time of the arrest. So I do anticipate that, but in the chance that I'm wrong and there is restitution, she is able to pay that today.
Are you pleading guilty of your own free will?
Yes, ma'am.
And Mr. Zick, I see you're back on this. Is there a preference for the people on which matter she should plea on?
No
I'm
preference.
just gonna plead. Okay. All right. So ma'am, back on, how do you plead to the charge of larceny?
Guilty.
Were you in the city of Taylor on January 31st of 2023?
Yes, ma'am.
And when you were in the city, did you go to Walmart?
I did, Your Honor.
And when you were at Walmart, ma'am, did you take some merchandise that wasn't yours?
Yes, sir.
Your Honor, I think she's stalling just because there was an attempt.
Here's where things should have gone smoothly. Owens' attorney comes in with what sounds like a solid plan. A plea deal. One charge dismissed. The other gets a guilty plea. And restitution possibly set at 0 since all items were recovered. Easy, right? Not for Owens. What starts as a straightforward exchange turns into a maze of contradictions. Watch how her lawyer tries to keep things professional while she hesitates, stalls, and flips her story mid-sentence. You can almost feel him praying the Zoom connection drops, so he doesn't have to keep explaining her behavior to the court.
To do so, but because she didn't leave with the items, I did discuss with her the legal nuances between those, and that there really isn't one. So, JC, do you understand the question? She's asking if you attempted to take any items for sale.
Attempted, yeah.
All right. Where was she stopped? Parking lot, or as she was exiting the building?
Before exiting the building.
Or as you walking out of the building, Miss Owens?
I was going towards the door.
I think she had just left the self-checkout area and was heading towards the door when store security stopped her and initiated.
And were there items that you didn't pay for when you went through self-checkout?
I mean, I don't know how to answer that. Honestly, Your Honor, I left the cart. I walked away from it. I don't know how to. And then the other one was, I think.
Hang on, JC.
Wait, so Miss Owens, did you put property in your cart or in a bag that you didn't intend on paying for?
This moment right here shows the danger of over-explaining in court. Owens could have simply said she made a mistake, but instead, she spirals into confusion. The judge asks a direct question. Did you take something without paying? And rather than a yes or no, we get a stream of half-thoughts, pauses, and contradictions. It's like watching someone try to build a bridge with no materials. You can sense the judge's patience thinning by the second as Owens dances around the truth, one vague excuse at a time.
All right,
Yes,
I can't
ma'am.
accept the plea, then we'll get a jury trial date.
Your Honor, I'm guilty.
Your Honor,
No, you're not guilty. Miss Owens, you've been through this before. You've got a ton of larceny convictions, right? This isn't your first rodeo. And ma'am, you're not required to enter a plea of guilty. But if you think you're going to sit here, I'm talking. If you think you're going to sit here and tell me that you didn't do anything wrong and think I'm going to accept your plea, you're sadly mistaken. I'm happy to have a jury trial. I like nothing more than a jury trial. You either want to accept a plea or you don't, and you're either going to be honest to this court and accept responsibility or you're not. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Are we clear, Miss Owens?
Yes, Your Honor.
So what do you think you did, Miss Owens, that makes you guilty of larceny?
Your Honor, the first offense, I didn't scan an item, and honestly, it wasn't to steal the item. I tried to pay for the item.
All right, so that's a not guilty plea. So, okay, we're going to just...
At this point, her attorney's doing damage control. He's clarifying, redirecting, basically try to patch the holes in her testimony before the whole thing sinks. But Owens, she's doing the courtroom equivalent of stepping on every legal landmine. Notice how she keeps shifting between denial and admission, a move that never ends well in front of a judge. This isn't just bad communication. It's self-sabotage in real time.
Let's go ahead and set these both for
But
jury
the second
trial.
one, I did intend to. So, I mean, yes, I'm guilty on the second. Yes.
You accidentally didn't scan $250 worth of items?
No, I didn't say accidentally. There was a computer or something
No,
wrong
on
with
the
that
first
scanner.
case, the allegation is that you stole 8 items worth $250. And you're telling me that was an accident?
Your Honor, I'm guilty.
We're going to jury trial.
Your
I'll
Honor,
set a jury trial date and we'll see you on that date.
Your Honor, if I may have an opportunity briefly in a breakout room with my
No,
client.
I've had enough of your client, quite frankly, and the games she likes to play. She's lucky I didn't revoke her bond the first time, and now she wants to play with whether or not she's responsible of this or not. And no, I'm not comfortable taking a plea. She's made it clear she didn't do anything. We're all set. You'll get your jury trial date in the mail. We're all set, ma'am. I'll see you on your jury trial date. Thank you.
And there it is, the breaking point. The judge officially rejects the plea and resets for a jury trial. You can hear the disbelief in his voice as he reminds Owens that this isn't her first rodeo. What's wild is how he keeps giving her an out, almost begging her to just be honest, yet she keeps tripping over her own story. When a judge tells you, I like nothing more than a jury trial, that's your cue that patience has officially left the building.
Ma'am, please.
You'll get notice in the mail.
I didn't.
Mr. Mikos, I'm sorry. I'm not tolerating your client and her nonsense. We'll set it for jury trial. If you talk her into taking a plea that she can reasonably put on the record without being full of nonsense, I'll consider it. But for now, we're going to trial. All right, we're back on the record. This is the People versus J.C. Owens.
Yes, thank you again, Judge Andrew Mikos, P76268 on behalf of Ms. Owens.
Miss Owens, tell me your name.
J.C. Owens.
Miss Owens, did we go over your constitutional rights a minute ago? Do you remember those rights?
Yes, ma'am.
Knowing all of that, how do you plead the larceny?
I plead guilty, Your Honor.
Back on January 31st of 2023, Miss Owens, were you in the city of Taylor?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
I want you to tell me what you did that makes you guilty of larceny.
I intended to steal items, Your Honor, without.
This is where the courtroom energy completely flips. The judge's tone changes from calm explanation to sheer frustration. He's done with the back and forth, done with the games, and flat out calls her behavior nonsense. It's rare to hear a judge speak this bluntly, but Owens leaves him no choice. Her own lawyer tries to ask for a breakout room, and even that gets shut down instantly. You can tell this judge's patience bar just hit zero.
What items?
I think, I honestly, I don't remember what items exactly, Your Honor. I think they were just normal, like condoms and stuff. Toiletries, yeah.
Did you take them with the intent to deprive that Walmart of their property?
Yes, Your Honor.
And did you take those items and put them in a bag without scanning them at self-checkout?
Yes, Your Honor.
Are you satisfied, counsel?
I am satisfied, yes, Your Honor.
All right. I'm going to accept the plea as knowing and voluntarily given. The case ending in 230962. That case will be dismissed per the plea. Meet with the probation department for a pre-sentence investigation. You're going to get notice of that in the mail.
Okay.
Finally, the truth comes out. After nearly 10 minutes of dodging, Owens blurts out the words everyone's been waiting for. I intended to steal. It's the kind of admission that could have saved the court 20 minutes, a few gray hairs, and a whole lot of frustration. The irony? The stolen items weren't even luxury goods. Just everyday toiletries and small products worth around $250. It's not the crime that shocks here. It's the self-inflicted chaos that came with denying.
And you're going to meet with them? And I'm sorry, Mr. Mikos?
No, go ahead, Judge. I'm sorry.
Yeah, I think we need an evaluation. So you're going to meet with the probation department, Ms. Owens, and they're going to contact you for a pre-sentence interview. After that interview, we'll meet again for sentencing. Are you still on felony probation?
JC, are you still on probation with Judge Matthews? Yes.
Yeah.
Okay. All right. Well, I'm assuming a lot of things will likely run concurrent, but I want my probation department to at least look at it. And Mr. Mikos, I can't give you a sentencing date because I don't know how backed up they are on their PSIs.
I understand.
So it'll be a Wednesday and we'll get it out to you in the mail as soon as they meet with her.
Okay. We're probably talking a few weeks out.
At least, I think generally 3 to 4.
Okay.
And bond conditions will just continue until that time.
Sounds good. Thank you, Judge, and thank you for your patience today.
All right, I'll see everyone at sentencing. We're all.
So, after all the twists, confusion, and courtroom tension, Owens finally gets her guilty plea accepted. One case dismissed, sentencing to follow, and her bond conditions remain in place. But the biggest takeaway? Accountability matters more than excuses. This wasn't about $250 worth of products. It was about honesty, integrity, and how quickly small lies can snowball into legal disaster. The judge's patience deserves a medal, and Owen's case is a masterclass in what not to do in court. If you found this case as unbelievable as we did, hit that like button, drop your thoughts down below. Was the judge too patient, or did Owens deserve every bit of that frustration?